General counsel here at Trinity University. So she's somebody who I've had the opportunity to spend some time with on campus. I know at the secondary level, you guys probably don't spend a lot of time with your university attorney, your district attorney, but Rachel is somebody who brought a really unique insight for us because her husband is an athletic trainer, and so she understands what we do and how we do it. So Rachel is going to talk to us a little bit about the legal aspect and what we can do to continue to protect ourselves. Which one do you want?
This is fine. All right. Hi, everyone. It's great to interact with you. I spend a lot of time with lawyers, and if you have not, one of the things that you will learn right away from me is that we have lots of caveats. So the first thing that you get to hear from me is that even though I'm going to talk to you about the law, I'm not your lawyer. And I'm not trying to turn you into a lawyer. What I want to do is raise your awareness about the legal landscape and the risk that you face so that you can start to think about the things that you can implement in part of your day-to-day life to reduce that risk for you and the organization that you work for. Hopefully, there are things that you hear today that you become curious about that you can take back to your school, to your campus, to your organization, and have more conversations about. But if you have specific legal questions, that's when you want to engage with your organization's attorney, okay? With that, I'm going to talk a little bit about the legal landscape and the nature of the legal risk that you all face as athletic trainers. I want to contextualize your role to broader risk that student athletes and the students in your schools have, and then I want to talk about some risk reduction techniques. So one of the common questions that I get when I get in a room with school administrators, professionals is, oh my goodness, can I be personally liable? Can I be sued? Am I going to be part of a lawsuit? And unfortunately, in our society, anyone can be sued for anything, right? We can't prevent that. But what we can do is position ourselves to be in the best possible situation to demonstrate why we've taken the actions that we've taken and why those actions were appropriate. And one of the most common types of lawsuits or types of legal action that you see when something bad happens is something called negligence. The idea that you didn't do what you should have done in a particular situation. And so I want to start by using an example that I'll try to carry through this presentation. And in doing that, one of the things I want to note is my husband is an athletic trainer and a physical therapist. You're actually going to hear from him next. You kind of get two for the price of one here. If you survive me, you get the reward of him. But also, I'm not a healthcare professional, right? So I've heard your language because it's in my house. I've worked, when I've been in my general counsel roles, with athletic trainers, with clinics, with providers, and I've worked on these issues. But I'm not in the trenches with y'all. So you're going to have to give me a little bit of grace as I talk about a hypothetical scenario because I may or may not use your language the same way that Val did. But if you think about the last decade and a common injury that athletes have, there's been a particular type of injury where we've seen a huge uptick of cases, a lot of news, and a lot of money that's gone into that. Can any of you think of a particular type of sports injury where we've seen a lot of risk? Concussions, that's right. And so we have primarily seen that in the NFL, in the NCAA, with colleges, but also with high schools, right? And so there was a particular settlement that made the news a few years ago, $4.4 million, because a school allowed a student to play when they allegedly should not have, and that student was injured and sustained permanent and very serious injuries. Okay? And so there is a lot of liability and a lot of finances wrapped up in this. And so how do those claims arise? What are they all about, and what can you do? So as I mentioned, the most common type of legal claim is something called negligence. And again, I'm not trying to turn you into lawyers, but I do want you to know sort of how that comes about or what the idea behind it is. There's this idea that we as people in society owe a duty to one another to behave or to act in a way that's reasonable so that we don't injure other people, okay? That's the basic idea. That then is specifically applied to circumstances where you're working in professional settings, and so for you as an athletic trainer, that duty to not be negligent says that you have an obligation to act as a reasonably prudent athletic trainer would in the particular circumstance. Okay? And so what those reasonable actions are going to depend upon what's happening in the context and in the immediate circumstances around you. And your conduct, the things you do, the times that you make choices not to do something, are all going to be measured against that standard of what a reasonable athletic trainer would have done. Okay? So that's the expectation that legally you're expected to uphold. If you do not act in accordance with the standard, that's called a breach of the duty. You haven't done what a reasonable person would do. And if that then in turn causes an injury, then there are damages that are sustained. Maybe the person has medical bills, pain and suffering, lost income, lost enjoyment of life, or the types of ways that lawyers try to quantify the bad thing that happens to someone. Okay, and so that's the context where the risk can arise. So for example, with the concussion case, if you have a student athlete that suffers from a concussion, you have duties within your profession and a standard of care that you need to use to assess whether or not they can continue to play, to practice. Okay? And there's a standard of care that because you are the healthcare professional, you've sat in the talks, you've read the literature. Okay? If you do not follow that proper protocol, and that student athlete then suffers additional injury because they were permitted to return to play when they shouldn't have, that's when a claim like negligence could arise. And that was the case when you saw that outcome that was settled for $4.4 million. So what informs the standard? How is that standard created? Well, it comes from a few sources. So the first is literally, what do the statutes and regulations in the state where you work say? Okay, so what is the Texas statute? And those can be things like your licensure requirements. So for example, you work under the direction of a physician. If you're working outside the scope of your practice, you all know that you're putting your license at risk, right? That's a personal risk for you. But what could also happen is that if someone is injured and they are able to tie that back to you working outside of the scope of your practice, someone could try to use the licensure standards as that standard of care, as that duty. Okay. The next are the professional standards that the organizations that you're a part of set. Okay, so Valerie talked about the NATA. They are a great source of resources for you all, as are BOC, the UIL, NCAA, or NAIA if you're a college coach. But these different organizations have best practice documents, guidelines. Sometimes they define for you or require you to have certain policies in place or to abide by certain practices. Okay? When a lawyer gets a case and they're looking at the potential liability, one of the things they look to is the best practice guidelines from your organization. Are you following those? They look to the organizations that your school is a member of. What are you supposed to have in place, and do you have those? So that's another way that the standards that you're expected to abide by are defined. Expert opinion. So as I said, the whole principle behind negligence is that you acted as a reasonable athletic trainer would under the circumstance. How do you know what that is? You ask other athletic trainers, right? So you find somebody like Valerie, who was just up here. You find somebody like a colleague that you have in this room, and you say, if this were to occur, what would your obligations be? How would you act? How would you assess this injury? How would you make a decision about if someone should return to play? And then they measure what that person says against what you did. Okay? Expert opinion. And then your policies. Okay? You all have many, many policies. I'm going to echo later on what Val says. You need to know what they say. Make sure you're reading them and practicing them. We'll talk about that. But your policies define what your standards are. And if something goes wrong and there is a policy that is relevant to what happened, the lawyers are going to point to your failure to follow those policies as your failure to follow your standard. Okay? So that is what creates the standard. That's what you're measured against. The good news is that there are lots of defenses, and even there's something called immunity, that lawyers will use to defend when something happens. And particularly, the one I want to highlight is for those of you who are at public schools in Texas. School districts and school district employees have substantial immunity or legal protection against lawsuits. So there is only a really very, very narrow ground where someone can actually bring a negligence claim under state law against public school districts. Okay, so you all largely are insulated from these basic negligence claims. Unfortunately, those of you who work at private schools or for an employer other than a school district don't have that. You do still have other types of defenses, and one of those is called assumption of risk. And I'm going to talk at the end about the importance of communication with student athletes, with parents, with coaches, with administrators. And one of the reasons that's important is because one of the defenses to these types of claims is that someone knew what the risks were and they voluntarily chose to continue to engage in an activity anyway. Right? And a lot of what you do is risk management with a student athlete, right? How much can you go? How long can you go? What's your pain? And so making sure that they're educated and their parents are educated about what the risks are if they do continue to participate and what the potential consequences are is very important, okay? Not just for the wellness and well-being of that athlete, but also from a legal perspective. There's one other that I want to briefly touch on, and I'm probably failing in my efforts to keep it simple here, but I feel like I need to note this. In Texas, because there is such great immunity from state law claims for negligence, lawyers have figured out how to bring claims in another way. And they do that in federal court under this idea that somebody who is a state actor who acts on behalf of the government, so that would include a public school district, engages in some activity that threatens or impairs someone's constitutional rights. Okay? And we actually have a constitutional right to our life, to liberty, to our property, and that has been determined to be in the court to mean that those sort of personal injuries, including loss of life, but also infringement on our bodily safety, is a constitutional right that can be violated by a public employee. So I note that because even though our public school district athletic trainers may be largely insulated from state law claims, lawyers have figured out they can now bring cases in federal court under the same sort of concept. Okay? An important difference is that the standard is not just a standard of negligence. It's not that you didn't act as a reasonable person. It's actually a much higher bar. You have to act deliberately indifferently. Okay? You have something called qualified immunity, and because of that, as long as you're not acting essentially in a reckless disregard for someone's safety, you also are defended from liability. Okay? So I know this is a lot, and as I said, I'm not trying to make you experts, but I want you to sort of understand the continuum of where that line is for the standard, what your obligations are, and when that liability can exist. So on this one hand, you need to make sure you're meeting that standard of a reasonable athletic trainer under the circumstance, and then under those federal law claims, it is a higher bar. Don't be deliberately indifferent to the risk to the safety of your student athletes. Now, you all are in this profession because you care about people, right? So even if you think that lower bar doesn't apply to you, right, we all want to act reasonably under the circumstances. All right, I want to switch gears just a little bit and talk about broader risk to student athletes. Since I was a general counsel for colleges and universities, and before that did some work with K-12 schools, I think a lot about the total liability that an organization has, and that includes the things that are on the screen. And one of the things that I have observed is that you all, as athletic trainers, have very special relationships and are in a position of trust with the student athletes at your school. And what that means is that sometimes people are going to tell you things, or you are going to observe things that someone who is not in your unique position is not going to have disclosed to them and is not going to notice. Okay? So we have students that are more likely to disclose some sort of trauma or the fact that they have been a victim of something horrific like a sexual assault to someone they trust. And that person could be you. So I just want to make a note, if you are a person working in a school and you do not know what your school policies say about the things on the screen, that is something that I really want you to take seriously and to look at. There is huge liability that can exist for institutions that do not properly respond to cases of sexual harassment, to incidents of hazing. You all have mandatory reporting obligations potentially under child abuse laws. And so I just want you to be thinking about, you all are in these positions of trust. If a disclosure is made to you, do you know what you should do? It's not only important for legal liability, but it's also important because it really matters for the well-being of your students, right? If somebody has been a victim or has had a horrific experience at your school, the number one thing we want to do is to get them the resources that they need to have access for ways to get help and to make sure that their whole person is cared for. So with that, what can you do to reduce your risk? And this is all of the fun things that I'm sure you like the least about your job. But in some ways, from a legal perspective, they are absolutely critically important. So I'm going to talk briefly about policies, documentation, communication, and your education. Policies. Have a policy, okay? Valerie talked about the EAP. If you don't have one, you need one, right? So I talked about deliberate indifference and the idea that you're deliberately indifferent to the safety and the well-being of students and how that creates liability. The negligence standard, that if you don't do what a reasonable person would, that you can be liable. Well, you are expected to have these basic policies in place, right? An EAP, absolutely. Probably a policy about how you deal with concussions, either if that's part of an EAP or separate. How do you handle bloodborne pathogens? How do you handle infectious disease? How do we handle COVID? Even though we like to think that the pandemic is over, it is not, right? But there are expectations within our professional organizations and within society that those policies are in place. So the very basic starting point is to have the policy. Courts have found organizations to be, or people to be, that deliberately indifferent standard, or to have failed to meet the negligence duty because there is an absence of policy. So the very basic thing you need to do is have the policy. You need to know what it says and follow it, right? So Valerie talked about reading it. I'm just re-emphasizing, if you're not doing that, you're creating a lot of liability for yourself. Enforce it and regularly review it. So a lot of us write a policy and we set it on the shelf and we go about life, and then we realize 3 to 5 years down the road, we haven't actually read it again. Set a time, a regular interval to review your policies. Is it still the right standard? Are we doing what it says we should? And if not, we've got to adjust our behavior or adjust our policy. Okay? It's not enough just to write it and forget about it. You've got to come back and regularly engage and make sure that you're keeping up with it. Because remember, what you do is going to be measured against what you say you're going to do. And what you say you're going to do is what's in those policies. Have good documentation. Okay? I know this is hard after you've seen a bunch of kids, you're exhausted after a long day, and this is something that can easily wait. But timely and complete documentation is so important. Having good policies and following your policies sets the standard and defines whether or not you're meeting your obligations, so does liability exist? But the documentation piece is what will save you if there is a lawsuit. It's what will save you if a parent or an administrator is second-guessing what you did and the decisions that you made and why a student was withheld or why a student played. Okay? When a legal case comes up, one of the first things that lawyers do is they request records. So if there's an injury involved, I want to see those medical records. I want to see those training notes. I want to see what I can know about the nature and extent of the injury, prognosis, the decisions that were made, and why those decisions are made. Why? Because the lawyers who aren't there in the trenches are then second guessing if those things were right. And lawyers like to say, if it's not written down, it didn't happen. Okay? Another thing to keep in mind is that when a lawsuit is brought, it is often years after an initial injury, and then it can be years after a lawsuit is filed before any witnesses are actually talked to. So you could have the unfortunate circumstance someday of having to sit in a deposition, an interview with a lawyer, to talk about decisions that you made relating to a student athlete. And they're going to put your notes in front of you, and it may have been 5 years or 7 years since you wrote those. Okay? So as you think about, what should I have in my notes? Think about, if years from now I'm looking at this, am I going to know, right? What was the injury? What was that student's condition? What were those factors that I used to assess them and make a decision, and what was my decision? You want to be able to have enough there that you can rebuild that so that you can defend the choices that you made and the decisions that you made, okay? And doing that timely, as close in time as possible to when you did that, is going to give you the most accurate picture. If you work for an organization that has guidelines for what you need to be documenting, if you're doing any billing, right, you know that you have to include certain codes or certain information. Also make sure you're complying with those things. Some of the pitfalls that I have seen when I have looked at medical records or defended people: missing and incomplete documentation. So you fill out part of the fields and you get busy and you forget and you never come back. Or maybe you keep information in multiple places. So you do your assessment here, but then instead of communicating the decision or the outcome in your notes, you shoot off a text to update the doctor or the coach, or you send an email to a parent, and that information is in a different place. Okay, so do you have all of your information together? Shorthands and abbreviations. So as medical professionals, there are certain acronyms that are standard in your profession. You know what those are. Any one of you could pick up notes that use those acronyms and know what those mean. But there may be others that over time you've created for yourself. Okay, so I can think back on my own shorthand for taking notes, and some of the symbols that I used when I started my career 15 years ago, I use those same symbols to mean a totally different thing now. Okay, so if I don't have a key or a way to keep track of what I meant, then I'm in trouble if I have to say what those things mean later. Okay, so just be careful in how you use that. Lack of standardization. Okay, not only is lack of standardization of sort of when and how you document less efficient for you, but it has a potential to raise questions later if someone's looking at your information. So one of the things that lawyers like to do is they like to compare the case that the lawsuit is all about with all of the other similar cases from the last 5 or 10 years. So they may actually be looking at de-identified records of every person you saw that had concussion symptoms for 5 or 10 years. Are you documenting the same type of information for every person that you see? Are you using a consistent assessment and consistent standard? Okay, those are the sorts of things that when people are unfortunately second-guessing you later, they're looking for. And then just lax record practices, so not saving everything that you need to. Like I said, if you're communicating by text or by email, maintaining those separately and not referencing them in your records. Okay, so whatever standards you're able to use to communicate, great, but make sure that you're tying that back, or you have a note that there's information outside of your EMR or outside of your hard copy record that also is relevant. Okay? Good communication. Communication is so, so, so important. Okay, I have a list of some of the stakeholders on the screen. Good communication and good relationships are just so important to everything that you do, but from a legal perspective, are also something that can actually prevent lawsuits from being filed later. Right? People don't want to sue the people that they like, the people that they have good relationships with, the people that they trust. Sometimes these things happen even when everything is done right because someone is just disgruntled or not trusting. Okay, and so it can go a long way to build your presence and the trust that people have in you with how you communicate what's going on. As I mentioned, if something does go wrong, that assumption of risk defense is also tied very strongly to communication, because if an athlete and if their family understand what the real nature of the injury is, what the real risks are if they continue to make choices to participate, or what the impact is if they potentially sit out, and then they're an active decision maker in those choices, knowing what the risks are, that's something that can protect you from liability, and that comes from communication. The other thing, even though this is outside of the scope, but I want to tie it into what Valerie asked in one of the questions that came about budget, is communication with administrators so that they do know what you're doing and why it's important is key. So I have been a part of an executive leadership team. I have sat at the table when we are making decisions about these 10 people have asked for this, and we only have $50,000 more dollars. Who's going to get it? Okay? Goals, strategic priorities are important, but guess what? Safety and legal risks are also huge. So if you have asks that you can tie back to liability issues, those are huge to your organization, not just from a financial perspective, but also from a reputational risk perspective. And the work that you do reduces the risk to organizations massively, and a lot of people don't realize that. And so becoming your advocate to talk about the ways that you contribute to those important aspects of the organization can also be helpful. And then finally, education. You're all here. You have to get CEUs, but hopefully you also know the value of that to your practice. Knowing the literature, coming and hearing from the physicians, from your peers who have taken time to become experts in certain areas of your practice are critically important to your ability to meet this professional standard of care. And connecting with your colleagues, right? We all deal with difficult circumstances, rare situations that come up where we may be questioning what the right things to do are. You have incredible networks in your organization that you can use to just continue to learn and to grow and make sure that you are keeping up with things. And not just you, but your coaches too, right? Because you can do everything right, but sometimes if your coaches aren't also on board with knowing and understanding and enforcing and following the policies or putting trust in you, that can be difficult. So part of that education piece too is educating others that you need to support you. So I hope that this was helpful in just getting a flavor of the potential liability that can exist and some practical steps that you can take to protect yourself. If anyone has questions, I'm happy to answer those, or we can turn it over to Adam so you can wrap up your day.
Thanks, Rachel. Any questions?